Good evening, or good morning, or good afternoon. Welcome back to our series of lectures on forensic investigation masterclass. Today we are having a session on interviewing of suspects. That is part 1, and then part 2, external forensic confirmations. We will start with the interviewing of suspects, and then we go on a break for about 5 minutes, and then we resume on external forensic confirmations. Interviewing of suspects is step number 7 of the investigation process, forensic investigation process. The general rule is that suspects are interviewed towards the end of the interview process. This is to enable the investigator to have documentary evidence and the witnesses' testimonies in the form of statements to use in interviewing suspects by asking those questions that will clarify the gaps or contradicting evidences already corrected. The evidence already corrected may also help in cutting off the denials by the suspects during admission seeking stage or interrogation. I've gone straight to discussing suspects interviewing because we had done interviewing of both witnesses and the suspects and defined what is interviewing. So the definition of what is interviewing is not within our discussion today. Exceptions to the general rule that interviewing of suspects must be done after the interviewing of witnesses. The following are the exceptions to the above rule. Number 1, suspects may be interviewed early to preserve their testimony if it is believed that their memory might fade if kept for long. This is their memory, not their. This should be changed to read their memory. Number 2, if the suspect is likely to run away. In this case, he or she will be taken into custody and then be interviewed before all witnesses are identified and interviewed exhaustively. Number 3, if threats to witnesses or other suspects are being made. Number 4, interviewing of suspects may take place during pre-engagement investigation to get more suspects or more witnesses and or co-perpetrators or conspirators. Next, we discuss the difference between interviewing and interrogation. This was not discussed during the lesson, during the interviewing lesson. Therefore, we are going to make it very clear here, the differences between interviewing and the interrogation or admission seeking process. Number one, interviewing is for the purpose of gathering information. Whereas interrogation is talking to the suspect. Sorry. You are talking to the suspect and accusing him directly. Number two, under interviewing, we are seeking information about the incident. We want to get as much as information as possible about the incident, how it happened, and at what time it happened, for how long it happened. Now, under interrogation, the investigators are seeking denial or admission. Number three, interviewing is rather friendly. In fact, it must be friendly for the investigators or interviewers to get maximum information from the subjects of the interview. Under interrogation, you will find that interrogation is adversarial. Adversarial means that it is not friendly. The suspect is now on hot soup, is being accused of having done the perpetrated the fraud or the crime. Number four, done before interrogation. Under interrogation, it is done after interview. This is the last stage of the interviewing step, if you would like. Number five, probability of being guilty is not known for or estimated. The probability is not known, or these four should be changed to or estimated yet. It should be or estimated yet. Under interrogation, probability of being found guilty is likely going to be the weight of evidence already corrected. The person under interrogation, that is when the investigation is being done professionally, should be the only person or persons that is most likely to be guilty of the offense. And therefore, the interviewing stage takes place as a filtering or a selection process of those who are to be taken to interrogation. If suspects are interviewed under interviewing stage and they are not found to be most likely to be guilty of the offense under investigation, then those people are not allowed to be to enter the interrogation room. It will be a waste of time. But the orthodox investigators take everyone, all the suspects into interrogation, and that is where they are beaten up, pinched very hard, so that they can give confessions which are false, which are later discovered to be false confessions. Number six, first stage of interview. Interviewing is the first stage, and interrogation comes in as the second and final stage of interview. Number seven, open-ended questions are used. This is where the subject of the interview is given time to narrate and then narrate, explain and explain, or what he or she knows about the incident. But under interrogation, closed-ended questions are used, rarely to Open questions are used during interrogation, because during interrogation you are supposed to either deny or admit what happened. Number 8, does not necessarily involve the police, because it is friendly. You do not need policemen around. Must involve the police, because it is very hard, and the subject of the interview who is being accused and faced with the weight of all the evidence that has been gathered might turn violent in his defense or in trying to express his guilt or conscience. Number 9, non-accusatory. The interviewer is just seeking information. Under interrogation, the process is accusatory. It's like the interviewer is telling the suspect that he has been caught. All evidences point to him or her, and therefore the only option he has is to admit that he did it and then give the confession statement. Next is the getting an admission. Asking admission or confession seeking questions. This is what will prompt the suspect, who is most likely to be guilty of this offense, to given and confess. The question is being asked here is to him to not to explain many things, but to accept some weight evidences, items of evidence, which point to him as the suspect. You can be asking a question like this: why do you think all the witnesses who were interviewed implicated you in this matter? Don't you think that the act of all of them implicating you is that you are guilty of this offense and you cannot get out of it? Yes or no? This is the time when you can display some items of evidence and ask him to deny it or to accept that evidence. No more explanations, because much explanation was done during the interviewing process. So admission or confession seeking questions, these are accusatory questions that are put to the suspect to make him either totally deny having got involved in the perpetration of the crime under investigation, or to admit and give a confession statement. Documenting an interview. Documenting an interview, we'll start with note taking. We noted during the stage of interviewing in the previous lesson that the interviewer is not supposed to be in the room alone. To have effective observation of the subjects of the interview and record all everything, including the body language, the interviewer should be accompanied by his co-investigator to act as the person to observe everything and take notes. So note taking is very important and it must be done by the co-investigator who must accompany the interviewer into the interview or interrogation room. So as you put the questions to the subject of the interview or interrogation, he will be noting the sweating, the nodding of the head, the staring by the staring by the subject of the interview is not looking directly at the interviewer, is staring at the ceiling board. You'll be noting that he'll be sweating and breathing faster, and faster as the interrogation progresses. You will be noting that. You will also be noting what he's saying in response to the questions put to him or to her. This will assist in analyzing and coming up with meaningful conclusions. Then number 2, recording of the interview. Some recording sometimes is necessary if the interviewing is complicated, or if interviewing the record is required to be played in a court, and if it is suspected that the person who is being interviewed might run away and then disappear. If the person being interviewed is probably an experienced investigator himself, and is expected to go to court and deny what he said in the interview or interrogation room, then the recording will be necessary, and recording cannot be done without express consent in writing. If that consent in writing is denied, then the interviewer must make application to the court for permission in terms of court orders to compel the subject of the interview to agree to the recording of the interview or interrogation process. If the recording is done without the consent of the subject of the interview, the person who is being recorded, without a court order, then the interviewer will be in trouble. The evidence extracted from that process will not be will likely not be admitted in court, because the correction of that evidence contravened the fundamental right of the subject of the interview. What if the suspect refuses to talk during interrogation, as they sometimes do? What will you do if the subject of the interrogation refuses to talk and he keeps quiet and he stares at you? You will note that the suspects have rights. They have fundamental human rights which cannot be trampled underfoot during interrogation. Those rights include keeping quiet. They can even decide to keep quiet even in the court of law, and then leave the court to decide what they are going to do with them. In accordance with the generally accepted legal principles, suspects have the right to maintain silence or be quiet until the end of the world. It is a human, it is not even a legal requirement. It is a human fundamental right. Human fundamental right that you can decide to keep quiet even before your executors, even when they are asking you whether you would like to be released from the execution. You have the right to keep quiet and let them do what they want to do. This means that suspects have the right not to answer any questions other than those about their identification and the criminal record. They can even refuse to answer questions related to their identification. What will you do? Keeping silent even in the face of threats to one's life is a fundamental right of any individual that cannot be taken away. Certified forensic investigation professionals or law enforcement are therefore not allowed to use force or pure outright deception to make the suspect talk and give information. Meaning that some dose of deception can be applied, but it cannot be overdone. If it is overdone and it is outrightly wrong, then that the evidence extracted will be rendered null and void. Techniques to make the suspect talk. If he keeps quiet or keeps quiet, the following is recommended. And I do recommend technique number 1 as persuasion. Talk about need for him or her to clear her or his name by giving the right information about the allegation. Tell him or her that by keeping quiet, it may be presumed that he has accepted all the allegations, all the information given by the witnesses and the other suspects who implicated him or her. Technique number 2 is persuasion. Tell him or her that keeping silent in the face of other evidence so far corrected, pointing to him or her as the crime perpetrator, will lead to the investigation team to conclude that he or she did it. That is technique number 2. Technique number 3 is there, persuasion. Talk about the social or family or religious consequences of being found guilty of the alleged offense. If you found out from the rapport building stage that the person before you is a pastor or a bishop or a respected family person, then you'll be using that information here to persuade him to talk. Tell him that it will be very shameful for the flock or the family to hear that he was presumed guilty and sentenced to many years of imprisonment just because of being obstinate and refusing to talk in the interview room, in the interrogation room. When talking about this, please base your persuasion on the information given to you during the introductory or rapport building stage of the interview. If the suspect had told you that he is a pastor or family person, please use this to persuade him to talk so that he is not wrongly presumed to be guilty be forwarded for prosecution and eventually be jailed and miss his charge, or a family suffering without a pastor or a father or mother. Technique number 4. Quote the evidence already corrected. This is very powerful. This is the last of the techniques you should use, but it's the most powerful. Tell him or her that the documentary and the witness testimonies point to him, and therefore he has several questions to answer, and therefore an opportunity to explain and clear his name. These are the 4 techniques that you can professionally use to persuade the person who has refused to talk during interview or interrogation. To not do the following. As a professional investigator, you must not pinch, press, or slap a suspect to make him or her talk. No pressing very painfully of the suspect or slapping. This is illegal and may end up in destroying your case. If after all the persuasion, the suspect does not talk, just include that fact in your report and proceed on to make conclusions as per the evidence already collected from documents, witnesses, and other suspects who implicated him or her. Techniques for making conversion statement denial proof. In some jurisdictions, it is required that the conversion has to be witnessed by the officer of the court. And in that case, you do not have a lot of problem because the suspect shall have conversed before a court officer. But if this is not a requirement in your jurisdiction, then you must be sure that this person will give you a conversion statement in the interrogation room and then denied in a court of law. So what will you do to make it difficult for him to deny it? Number 1, make deliberate mistakes that the suspect will easily notice on every page and let him or her correct and countersign on every page 2-3 times on every page. Ask him or her to sign at the bottom of every page of the statement in addition to what he or she did in number 1 above. Number 3, let the subject sign at the end of the statement also. The opposing counsels find it very easy to advise the suspect to deny conviction when there is only one signature at the end of the statement. But if it is like this, their hands are tighter. They will fear advising him to deny it, because if he denies that such statement in a court of law, then that might make his case worse. He would prove to be outrightly dishonest before the court. In a conclusion, I would say that the above will make it very difficult for the suspect to deny the statement for the reason that you forced him or her to sign the statement without reading, since the corrections and signatures will be evidence enough of the reading. Thank you very much. This is enough for the training on interrogation or interviewing of suspects at this training level. Interviewing of suspects is like a forest. It is interviewing, the subject of interviewing and the interrogation, it is a course on its own. A seminar can be called or a workshop to discuss interviewing and interrogation for 5 days, and the 5 days will not be enough. So I've done all this summary for the purposes of forensic investigation masterclass at this level. You are now allowed to take 5 minutes break, and then we come back to do part 2 of this lecture, of this session. Let us resume. Only seconds are remaining to end the break of 5 minutes, and I will start with a comment from Hans Peter Kirumbi from Tanzania for thanking us for the first part of the session. Then we have Cornelius making that comment. Thank you too. We have more than 2 people in the training room, but only 2 people have participated. They have indicated that they are present and that they are paying attention to what is going on. We encourage others to do the same because that it is good to do so. Let us now resume on forensic independent confirmations. We did some introduction earlier on to this part of the session, and therefore I'm going to go through this part very fast so that we have time for questions and a discussion. Forensic external independent confirmations is step number 8 and the second last step in the forensic investigation process. The forensic external independent confirmations are a complex area of evidence gathering, since they require other techniques that go beyond numbers. It involves intelligence gathering to some extent, and therefore bringing in the challenges of human weaknesses. Confirmations we are discussing here today are not exactly exactly the same as those discussed in the ICE standard. There could be some similarities and interceptions, but forensic external confirmations are aimed at corroborating the evidence already gathered. There may be similarities, as I've said, but also the mindset of the CFIP of the investigator is different from that of the auditor, since a certified forensic investigation professional must reach a stage where he or she steps out of the figures examination, testing, and confirmations to intelligence seeking to confirm some matters that are completely outside the realm of financial figures or statements. Put simply, professional forensic investigation is interested in getting independent information and also documented evidence from those outside the organization who may not have interest in cooking anything. These are referred to as forensic independent external confirmations. What are the differences, therefore, between the auditor's confirmations and the forensic confirmations? What are the differences? The differences are as follows. Number 1, the mindset of the investigator is to collect independent evidence that corroborates the other evidences already gathered. The mindset of an auditor is to confirm assumptions or balances in the financial statements by getting audit evidence from independent sources. Number 2, the forensic independent evidence is for presentation to a court of law. The audit evidence is to support the opinion of the auditor. Number 3, the focus of the forensic investigator is on figures as well as non-figure information, like in the investigation of credentials fraud. The focus is purely or to a great extent based on financial statement balances. Number 4, it involves independent interviews with the external parties to extract evidence. A good example of this is the interviewing of former staffs who in the process reveals hidden bank accounts. Does not involve any kind of interviewing. Number 5, involves undercover investigation techniques. Under audit confirmations does not involve any undercover operations. Number 6, involve tracing and surveillance, especially when it try to uncover hidden assets. Does not involve any kind of tracing and surveillance. Number 7, involves social or media announcements, press releases, and analysis. But under audit confirmations, that it does not happen because audit confirmations does not go do not go that far. Next, the above list is not exhaustive, but gives a glimpse of what forensic investigation entails as opposed to conventional auditing as far as independent confirmations are concerned. The general rule is that evidence provided by external parties is more reliable than the information given by the client staffs. This makes the CFIB to dig deep and outside to gather evidence that would either support or dispel the allegations being investigated. Sources of external independent evidence. The following are the sources of external evidence for the purpose of forensic investigation. Number 1, banks. What will you get from banks? Bank balances at a given date. When information on the balances is accompanied by bank statements, discovery of hidden bank accounts is possible. Now, C, confirmation whether or not the wrongdoing under investigation involved actual withdrawings of cash from the bank accounts. D, confirmation as to the signatories of the bank accounts. E, loans for investments that are not reflected in the financial statements. F, standing orders for settlement of liabilities that are not reflected on the financial statements. Next. Suppliers. Disputed balances, that is A. B, confirmation or otherwise of the balances in the financial statements. C, cut-off manipulation, confirmation. D, omission of liabilities for goods and services supplied to the investigative organization. E, fraudulent overpayments to suppliers with an aim of claiming refund and then channel it to the wrongdoer's bank account. Number 3, customers. What information will they give us? Disputed balances and ends over or under valuation of debtors or accounts receivables. B, confirmation or otherwise of the balances in financial statements. C, cut-off confirmation. D, omission of debtors for goods and services supplied by the investigative organization. And at this point, we will discuss the scheme called teaming and raiding. Teaming and raiding is a bookkeeping fraud, also known as short banking, delayed accounting, and wrapping. It involves the allocation of one customer's payment to another customer's account to make the books balance, often to hide a shortfall or theft. Teaming and raiding is a method by which a person who takes or handles payments uses the money personally for some days and post the transaction later. The handler receives cash, uses it for personal purposes instead of depositing it. A common practice trait in this fraudulent activity is that the amounts received from the subsequent debtor or account receivable is credited to the earlier debtor's account, so that one debtor's account does not show an outstanding balance for a long time. To make up the shortfall, when another payment comes in, the handler will deposit that money against first money used, and it does not show the new amount received until later. Such a process is continued until the time the original amount misappropriated is finally replaced, or until the cashier is caught. Another similar strategy is applied when remittances are received by means of checks, where checks are split up to record payments. This is known as splitting checks. By encashing the checks, less amount is credited to the debtor and the rest of the amount is misappropriated. Next, former staffs. Hidden assets can be revealed. Hidden documents and fraudulent channels passed to cook and roast the financial statements can be revealed. C. Hidden forged checks can be revealed. D. Hidden bank accounts can be revealed. D. Collusion of two or more staffs in the wrongdoing in being investigated can be able to be revealed. The co-perpetrators can be able to be revealed by the former staff. Universities and colleges. What information can be received from these institutions? This is A. This is used to unearth or rather confirm educational and professional credentials fraud. B. Confirmation of actual attendance or enrollments with listed institutions. C. Confirming state of memberships, whether suspended, deregistered, or in good standing. D. Confirmation of completions and graduation dates. D. Confirmation of programs or courses undertaken. Former employers. What information can we get from there? Positions held by the person, vis-a-vis what is indicated in the CV. Reasons for leaving vis-a-vis what is indicated in the CV. Dates of appointment and leaving vis-a-vis what is indicated on the CV. D. The person he or she last reported to vis-a-vis what is indicated on the CV. All this will be traced to the CV, filed with the application to confirm the integrity of the candidate under consideration. Registrar of companies or company's house. A. Company or business ownership can be discovered. B. Shareholdings in the company can be revealed or discovered or confirmed. C. Confirmation of type of company. D. Change of ownerships. E. Dates and the year of incorporation can be confirmed. Next, registrar of motor vehicles and related machines. A. Ownership can be confirmed. B. Confirmation of registration. C. Dates of registration can be confirmed. D. Former owners of the vehicle or equipment can be, or machine can be confirmed. E. Transfers, if any, can be revealed or confirmed. F. Type of motor vehicle can be confirmed or revealed. Number 9, lands or deeds registry. A, ownership can be confirmed. B, confirmation of registration. C, dates of registration. D, former owners. E, transfers. F, types of deeds, leasehold or freehold. Next. Application of the independent confirmation evidence gathering technique. The certified forensic investigation professional must first consider whether or not external confirmation evidence is likely to be to significantly influential on the overall decision to prosecute or not. In short, it is being said there that the investigator should decide whether he requires external confirmation evidence to be part of his evidence for prosecution. As always, however, independent confirmation's evidence is made to fill the gaps in the already collected evidence from other sources, and therefore it will be found very necessary to the overall investigation decision. It always plays an integral role on financial statements fraud and credentials forgery investigation. The role of management. In the case of financial statements fraud investigation, management should not be informed of the intended independent confirmation since they can play a counterproductive role. You never know. There could be potential suspects in management that can quickly design ways of influencing the outcome of the independent external confirmation. When it comes to credentials inquiry, management is usually the client and therefore would know of the intended sectorization, but it never disclose your techniques in details. Even the recruitment team should not get to know your investigation plan for getting independent evidence on educational and professional certificates presented by the applicant. Next, time is running away very fast. We should also run. The process of independent confirmation. It starts by identification of the institutions and companies or individuals to be secularized or fisted, drafting the secularization letters and planning the feasts to the institutions. Number 3, sending out circulars or making independent feasts to the target institutions or companies or individuals. Next, receiving responses and analyzing the same. Uh, Analyzing responses received, making follow-ups on the responses not received. A forensic investigator does not take non-response to uh, external confirmation requests rightly. They must make follow-ups and even carry out some other procedures, alternative procedures of investigative procedures to get the appropriate and relevant uh, evidence for the completion of their investigation. Number 7, evaluating the responses received for residual for evidential value. Under that, you will consider reliability, authenticity, and also background of the person from whom the external evidence is received. And then, as we run fast to the end, Advantages of external confirmation. Carrying out external confirmation tests can prove very good uh, evidence or for the offense, against the offense. Omitted or understated liabilities can be revealed. Omitted or understated assets like bank balances, account receivables can be uncovered. Tracing misappropriated funds to the subject's bank accounts can be revealed. Omitted long-term investments that are financed by loans that are also omitted can be revealed. Forensic independent confirmations evidence is more reliable than the other types of evidence except documentary evidence. Number 7, investigation evidence obtained directly by the investigator is more reliable than evidence obtained indirectly or by inference. Next, how to investigate educational and professional credentials fraud. The fraud or forgery involved are as follows: forged or altered documents, fabricated counterfeit documents, inside jobs, and creative transactions. Degree or diploma made products. How to do the investigation? Carry out the analysis of the certificates to identify the institutions that are purported issuers of the same, noting the dates when they were issued. And number 2, matching the information above with the CV or resume that was attached to the application for employment or admission, as the case may be. Number 3, personally visiting the issuing institutions, because sending requests for references do not work. What if you send a reference letter and then it falls on the desk of a relative? What do you think? What result would you expect? He would confirm what you wanted him to confirm. So, in trying to fix the institutions, sometimes the investigator or investigators might do it undercover so that they are able to correct information by themselves directly without asking any person who openly who might mislead them. Another technique is to seek ways of verifying the admission number on the certificate. Conclusion. Any conclusion In conclusion, the external or independent forensic confirmations must be done from outside the firm or institution where the investigation is taking place. This kind of evidence is particularly applicable to financial statement fraud and educational and professional credentials fraud. Thank you very much for uh, listening to me through this very long presentation. We have 2 minutes, 2 or 3 minutes to go through the comments which have been made by the participants, and I can see that one from Munyarazi Simbi. That is what he says. Thank you, President, for shortening the course and giving it a precise explanation, a thorough insight on the differences of interview and interrogation. CFIB Simbi from Harare. There being no other question, no questions or other comments, and the time is up, I would like to say thank you very much for your participation. Please, we have done a lot. If any one of you is interested in getting a participation certificate, either for the purposes of enrolling for advanced training, that is the professional course, you are requested you are requested to do the tests which are already recorded on YouTube. There are 3 tests. Attempt them and send answers to us for marking. If you are successful, you will be taken through the process of certification. If you are already a certified member, and especially those who came from direct admission, please do also the tests for you to get your CBL or the points for the purposes of renewing your membership. Because from July 1st, we will not be renewing membership unless one source gives us proof that he has been updating himself on forensic investigation. Thank you very much, and